A very limited case law on jury tampering and the standards by which judges, trial judges, should evaluate that, and that's really a central issue here. So I think this case will be, in my view, decided on that issue, with this court clarifying how and what the standard is for jury tampering.
That was Columbia Attorney Joe McCullough earlier today laying out the central question in this appeal, whether the jury was tampered with when it comes to Becky Hill and the former clerk of court in Colleton County.
And joining us right now on Friends at 5 is attorney Brian Shealy. You stuck around for our second half hour. Thanks so much. We do want to start by asking you, you talked to me about there was something unusual when it comes to who was arguing at the Supreme Court today. Can you explain that?
Yeah, I mean, it's normally trial lawyers are trial lawyers, and if there's a conviction, they file for appeal, and there are appellate lawyers that just do the appeals. And so today, amongst all the unique aspects of this case, you had both trial lawyers for the defense and the state arguing before these Supreme Court justices, explaining their actions. Normally there's a lawyer that was not involved in the case at all, that is reviewing a record of a trial and making the best arguments that they can put together for the defendant. And so here it was very unique, very accomplished lawyers on both sides that were able to explain themselves to the court.
Yeah.
I'm curious about the time limits today, because originally we were told it would be 30 minutes to argue on one side, 30 minutes on the other, then a 10-minute rebuttal. Then we were told it would be 20 and 20 for each appeal. There were 2 appeals today, so 20, and then the 10-minute rebuttal. But this thing went a lot longer than those 20 minutes. In fact, it was like 30, 35, 40 minutes at times.
And JR, the rule of thumb is do what the judges say. So if they're going to allow it on these issues and there's more examination and questions that are being covered, and as long as they're permitting it, then yeah, I mean, they can allow for more time, more rebuttal, more arguments. And that's what I watched today, was a very intellectually interested group of Supreme Court justices that were trying to get all the issues covered.
Is that to be expected in a case of this magnitude? There were so many transcripts to go over here, a 6-week-long trial, so much happening with this case. You would almost expect the arguments to go past those time limits.
It was not unexpected, JR, and I think with the length of the case and the transcript and the record and the judges having more and more questions, I think it kind of naturally unfolded that way. So I think that was normal for this case with the magnitude that it had.
And for anyone who is just now joining us, was there one thing that really stuck out for you as we sit here and have this conversation and think about earlier this morning?
I mean, I think obviously it's Becky Hill, and the way the justices were describing her actions. They weren't trying to mince words on the standards of, jury tampering, some of the legal issues. They were getting right to the meat of it, what she did. And then I think there was a lot of analysis from the justices. And in my opinion, it was disapproval of the state at the trial level introducing the financial crimes. Creighton Water was doing his best job to talk about, tying it all together for the jury and the motive, and I don't think the justices were buying that, and that stood out to me.
It could be days, weeks, or months before the state Supreme Court makes a decision, but what is your gut telling you tonight?
I'm hungry. My gut tells me that this has to come back, JR. If it doesn't come back and the misconduct of a clerk of court is allowed to uphold a verdict like this, then it cries out for, I'm scared for future juries in South Carolina. So I think it comes back. I think it is, like I said, I've said it multiple times, really it's nobody's fault. It is an outlier within an amazing case in and of itself that no one expected. I think if the justices don't bring this back, it would be a miscarriage of justice.
When you say bring it back, that would be a new trial?
Remand it for a new trial would be the decision if they grant the defendant's appeal. And then, of course, the state would then very likely appeal that up. So we're not done.
Yeah, and we know this case has nationwide attention once again on the state of South Carolina. When I interviewed you weeks ago, you talked about the precedent that this is going to set as well.
Yeah, I mean, it's the precedent is the facts of this case are unique and astonishing, and then what happened within the hallowed ground of the clerk of court's office and the jury deliberation room is unheard of. Mm-hmm. There's never been in South Carolina a more intentionally inflicted you know, bias by a member of the courthouse who is, as the justices were saying, you know, the clerk of court signs the checks. You know, she's there, you know, telling them what to do. She is, you know, their boss essentially in court, and then she's telling them certain things about what to expect or preview what you can think of, what you should think about a defendant when he's going to testify, and that is unheard of, and really the cornerstones of our constitutional criminal justice system fail if that is allowed.
All right, criminal defense attorney Brian Shealy, thank you.